It's the bank accounts that result in somebody having to do probate. Do you want to pay the filing fee? Do you want to pay what's necessary to do it, to empty out what may only be a $2,000 bank account? It doesn't have the proper beneficiary or transfer on death on the account. That bank is not giving up that money.
Welcome to Tailored Wealth. I'm your host, Taylor Mavrakos. In my 10 years as a financial advisor, I've seen that when it comes to financial education, women are always an afterthought. My intention with this podcast is to create a space tailored to women as they navigate financial choices throughout their lives. And speaking of lives, today we're going to talk about estate planning with the one and only Jennifer Beltz. So Jennifer, thank you so much for being here today.
Thank you for having me, Taylor. It's a pleasure.
So let's talk a little bit about estate planning and how you became an estate planning attorney.
Well, I definitely took an indirect route. This is my 28th year practicing law. And the most of it, if you recognize my name or the name of my firm, we have dedicated most of our lives to personal injury work. But a lot of what I do also is representing families of people who have been injured in a nursing home or an assisted living facility. And we started noticing a trend where if the paperwork hadn't been done, their estate planning hadn't been done, it made it difficult, sometimes impossible for us to get records. And it also, in many occasions, would limit who could actually bring the claim on behalf of the family. So we started seeing this trend and thought about possibly expanding our practice to estate planning in hopes of helping these people before they need it. And in 2020, we really took that opportunity because during COVID, the courts were closed. And so it really gave us that opportunity to expand into estate planning. And it's become a very robust part of our practice now.
So when it comes to estate planning, whenever I bring it up at my office, people are like, well, I'm not going to die anytime soon. What do you say to people when they say that? And when is it ever too young to start thinking about estate planning?
It's never too young. And I would say that part of the reason people think that is because when you think of estate planning, people are always assuming you mean a will or a trust or things that happen after I'm dead, right? And no, I'm not thinking about that. Nobody wants to think about dying. But estate planning is so much more. And in fact, for us, when we are talking with our clients and giving them advice, our recommendation is the documents that are the most important and now are the documents that you need while you're still alive. Your power of attorney, your healthcare surrogate, your living will, that's all part of the estate plan in addition to a will and perhaps a trust. And people don't think about the fact that if they don't have those documents in place and become incapacitated, no one knows who's supposed to take care of you or who's going to make their decisions, and your own wishes may not be followed.
So to kind of define some of those, power of attorney, what is that?
So a power of attorney is essentially, it is a very powerful document. It literally has the name in that word in the name. And what it does is it's essentially, I try to describe it as if I were to clone myself. And so anything that I can do for myself, whether it's signing my checks, paying my bills, talking to my doctors, purchasing real estate, buying investments, anything that I can do, I am designating another person to have that authority. And in Florida, our powers of attorney are immediate. So when you give a power of attorney to somebody, they literally could go in and drain your bank account. So I always tell my clients, look, what I would recommend, we can either hold the original document in our office and keep it under lock and key until such time as you've given us instructions when it's okay to give it to that person, or you please keep it under lock and key. Don't give copies to anybody and keep it in a safe place where the person that you've designated knows how to get to it in the event that they need it, but they don't have access to it right away because it is extremely powerful.
I like that. So when you're picking who will be your power of attorney, figure out who you think is closest to being your clone.
That's a really good way of putting it. For a lot of people, it's going to be their spouse. It's going to be their partner. Sometimes it's a fiduciary, somebody who has, no personal relationship necessarily, but does have a fiduciary relationship and responsibility to take care of you properly.
When I go over estate planning in our office, and I'm not an attorney, what I always say is just, is it durable? Can you go over what that means?
A durable power of attorney just simply means it's an actual power of attorney. It's a term of art more so than anything else.
So
once it's executed, it's durable.
Nice. Okay. Good. So then we've got a healthcare surrogate.
Mm-hmm.
Is that your power of attorney or is that different?
That is a different document. So you can have a power of attorney that includes making healthcare decisions, but you may not always want that to be the same person. And so and not only that, a healthcare surrogate is simply a designation of somebody who's going to make those healthcare decisions for you. So let's say you're in a car accident, you're taken to the hospital, you're incapacitated. Do we need to, what kind of health does this person want? How do they want to live? What kind of decisions they want made? The healthcare surrogate form will tell the doctor who they need to contact. And the benefit of having that separate from a power of attorney is that that's a document that you can keep copies of in your medical chart, as opposed to, you probably don't want your power of attorney, floating around. But your healthcare surrogate just is for that specific person. And it's something along with your living will, for example, that you can keep in your medical file so your doctors know who to call and what your wishes are.
So when you make your healthcare surrogate, give a copy to your primary care doctor?
I recommend that.
Okay, interesting. What is there a difference between that and an advanced directive or healthcare directive?
Yes. So healthcare surrogate is literally just naming the person that's going to make healthcare decisions for you. An advanced directive or a living will literally talks about what types of measures you want in the event of your incapacity. And so a living will has a very specific list of things that if you're in, and we think about a lot of times, like we think about the Terry Schiavo case, someone who, is essentially in a vegetative state, what did they want done for them? And so a living will is what gives that information to the doctors that are caring for you.
Things such as do you have a do not resuscitate or?
That is true. A DNR is actually a separate document. And
so many documents.
There are a lot
Jennifer.
of documents. And do not resuscitates are usually provided by the medical community because a lot of times if you have an elderly person living in a home and they have a DNR, it's going to be a bright yellow thing that they usually keep on the refrigerator. So if something happens and EMS comes to the house, they will see that you have that DNR in place.
An advanced directive is the same as a living will?
I wouldn't say they're exactly the same, but they're relatively interchangeable.
And that's something to where, for example, when we talk about you're never too young to have it. If you get into, God forbid, a car accident or you become incapacitated for some reason, that document specifically and the healthcare surrogate can help you when there's any kind of decisions that need to be made.
Correct. It helps your family make those decisions, especially, and it's even in the document itself in the living will that you're telling your family members or whomever it is that you want to make that decision that this is your choice and that they should not have any guilt over it. They should not feel bad that this is what they want, that this is what they're actually wanting to do, and this is how I want to be treated. And so it's really important. And a living will really just identifies what your wishes are. It doesn't designate someone to specifically make that decision. It tells the medical provider, I don't want these types of care in the event that I'm in these certain circumstances. And again, like I said, it also has that language in there. Don't feel bad about this, mom and dad or sister, whomever, this is what I want.
So then going off of that, I feel like my younger clients, when you come out of college, you're an adult. If you throw around the term 401k, they're like, I have a 401k. They don't even know what it means sometimes, but that's how you become an adult. I feel like when you become kind of a more mature adult, you're getting up in years, you've made it in your career. The fancy word is trust. Everyone's like, I have a trust. Like you haven't made it in this world unless you have a trust. Can you explain what a trust is, what a will is, what's the difference? Do we need them?
So everyone should have a will because a will is the one thing that when you do pass away, your original will gets filed in the court file. It doesn't mean you're going to have a probate. It's just filed to let everyone know this person has passed away. And so that's something that everyone should have. Now, whether you need a trust really comes down to where you are in terms of what assets you have, what your family situation is like, what you're looking to do with your assets if and when you pass away. People that have young children, and if they're likely to pass away and their kids are going to need to be cared for, a trust is an excellent vehicle for that. Ultra wealthy families, obviously, because the benefit of a trust is to avoid probate. And so obviously, if you're ultra wealthy, you want to avoid probate tax. So a trust is a vehicle to allow you to do that. If you have adult children, for example, and maybe you're just not comfortable leaving them a giant sum of money at one time when you pass away. A trust is a great vehicle for saying we're going to disperse funds over time at a schedule, and that allows you to have a little more control over that as well. It also, if you're married and the one spouse passes away, everything the trust then becomes in the hands of the other spouse, and it's still revocable, meaning they can make changes once both spouses or both grantors have passed away. Then it becomes an irrevocable document and everything is dispersed according to the terms of that document. So not everybody needs a trust. In fact, like I said, when I meet with clients, it really depends on what their circumstances are. So if you're single, you don't really own real estate, you don't have children, you've got your 401k, you've got your bank accounts, you've got your life insurance, and all of them have beneficiaries designated, you may not need a trust. But if you have a trust because you've got young children or some of the other examples, the benefit of that is going forward, any additional assets that you obtain, you can name the beneficiary the trust, and therefore everything pours over into that trust at the time that you pass away.
I'm so glad you said that, because when people come in my office and they're like, oh, I have a trust, the first question I have is it funded? Because the majority of trusts aren't funded. Can you explain what that means?
Absolutely. And you're absolutely right. It happens all the time. People think, oh, I got this trust document. But if you've never actually poured your assets into it, whether changing the beneficiaries of them, renaming them, depending on if maybe it's real estate that you want to rename into a LLC and you want to add it to your trust. If you haven't actually done that, the trust is just a piece of paper. It doesn't mean anything.
They're literally just like, I feel fancy.
Right.
Like, I'm an adult.
I've
I
got
did
these
it.
cool documents, but when I die, guess what? Nothing happens to them because there's nothing there. And it can be real disappointing to someone who's expecting to receive something from the trust to find out that it was never funded in the first place. So that's one of the things that we do as well, is give them an instruction sheet explaining how to change the beneficiaries, how to fund that trust. We also give you sort of a condensed version of the trust to hand over to certain vendors like your bank. You don't need to hand them over the entire trust. They'll ask for it, but they don't really have to have it. So we give you this sort of Reader's Digest condensed version that you give to the bank so they understand the general terms, but they don't see the entire document.
If you have a trust, do you need a will as well?
Yes. So the reason you would, first of all, everybody should have a will. So that's straight across. In your Venn diagram, everybody needs a will. Not everybody needs a trust. So, but with regard to the will, even if you have a trust, you want to have a will because there may be something that you accumulate later that doesn't get into the trust. You may have forgotten about something when you're talking with your lawyers. You haven't, forgot to fund an account or something. So there still may be these random things that are in there. So what we always do is we write a will that's called a pour over will. And essentially, unless you have specific things that you want to leave to people, like I want Aunt Joan to have the silverware or something, basically all it says is everything that's left over that isn't already in the trust gets poured over into the trust. And so then it's dispersed according to the trust document.
So when somebody is looking to hire an estate planning attorney like yourself, as they add assets, do you create like amendments? Is that how it works?
You can. It depends on what the asset is. So if it's simply changing or adding the trust as the beneficiary, that doesn't require any amendments to anything, because essentially any asset that you have that has the trust as the beneficiary is going to go into it anyway, by definition. So you're not going to have to amend the trust itself. The only time you would amend your trust is if you're changing who's receiving something, if you're changing your beneficiaries. I have a client who makes changes constantly, and that's just part of the deal. So most of my work is flat fee when it comes to estate planning. Although if there are clients that need consistent changes because they've got a large estate, those are going to be more of an hourly rate, but the bulk of it gets paid as a flat fee. And for the most part, if someone has small amendments periodically, we generally do that at no cost.
Something that, as a financial advisor, it's interesting because we have to know about estate planning, but we're not attorneys. So what I tell clients is that on your account, so for anyone watching today who is like, oh my goodness, I have no estate planning done and I have to hire an attorney, and what if I get in a car crash tomorrow? What happens to me? The first thing I would say is that there are a lot of free tools that you can use today to get your account set up properly. The first is making sure that all of your accounts have beneficiaries on them. So your investment accounts, what I always advise clients is we can make primary beneficiaries, secondary beneficiaries, and that's free. It's included with your investment account. If you want something more complex than that, if you don't want someone to get a lump sum, if you want someone to get paid out over time, that's where you have to hire an attorney, because the free stuff will only get you so far. So you can do it today. Make sure there's beneficiaries on your 401k, your 403b, that's a retirement account. If you're at a government agency or nonprofit, make sure that you have the beneficiaries on there. Same with bank accounts. They're called POD. There's POD, TOD, ITF, and beneficiary. Pay on death, transfer on death, in trust for, beneficiary. What's the difference between them, Jennifer?
I don't think the bank cares one way or the other as long as they know who to send it to.
There isn't a difference. They do it to make it confusing. So the pay on death and the POD and the ITF are going to be for your bank account. TOD is for non-retirement investment accounts. Beneficiaries are on IRAs, at least as far as I know. But make sure, and a lot of times your online banking, you should be able to have some kind of PDF where you can fill it out. You can go to the bank and ask for it, get beneficiaries on all of your accounts. And then while you're going through the process of working with an estate planning attorney, at least you've got a baseline to cover yourself. Because the other word people say a lot is probate. And you've said it several times. And I've had so many clients go, well, you don't want to go through probate. And I'm like, do you know what that is? And they're like, I just know you don't want it. So they don't want it. But can you explain what it is?
Well, as best I can, because I don't do probate personally. I do refer that work out. So basically, if someone has passed away and the assets were not properly, didn't have proper beneficiaries on them, in order to access those, you have to open up a probate and have somebody appointed a personal representative. If it's a minimal amount of money, I believe the threshold right now is either 50 or 75,000. It can be a summary administration, which is literally like kind of opening up this quick file, naming this person, they close out the accounts, and it closes back out again. But the problem with probate is that when you have a situation where the person didn't designate where they want things to go, and suddenly all the family members are fighting over it, that's when probate gets expensive. That's when people get lawyers involved to sue each other to try to figure out who wanted what, why I didn't get my share and everything. So the more you can do to plan, whether it's leaving beneficiaries on your accounts, like you said, which is incredibly important, or doing your estate planning, that will eliminate that issue with probate. It's not something anybody wants to have to go through. And I will tell you, it's amazing to me. You're absolutely right about bank accounts, because invariably it's the bank accounts that result in somebody having to do probate. And then it becomes literally a discussion about, do you want to pay the filing fee? Do you want to pay what's necessary to do it, to empty out what may only be a $2,000 bank account? It may not be worth your time or effort. And that's frustrating, because they still should get that money. But if it hasn't already been transferred, doesn't have the proper beneficiary or transfer on death on the account, that bank is not giving up that money unless the estate is opened up.
I always tell clients, again, every interaction, you've got a winner and a loser. My loser, I have no problem saying it, is always the credit card companies and the government. Don't pay tax dollars. You don't need to pay. Yep. The probate is a fancy way of saying, instead of the money going to the people you want it to go to, it's going to go to expenses. Are they technically taxes? Is it the government? Who's getting this money?
Well, basically what happens is when you open up a probate, and we do this in our personal injury side of it, when we have somebody's passed away, we have to hire an attorney to do probate. When you open up probate, if you know of any particular creditors that person had, whether it's a credit card, whether it's a mortgage, whether, whatever debt they had, you have an affirmative obligation to notify them directly that this probate has been opened, this estate has been opened. You have at that point 30 days to file the claim in the estate. And so any money that goes into the estate gets paid to those creditors first. So if you don't know them, then you do a publication. And again, this is really getting outside my area, but just my general knowledge of the process itself. You do a publication for a certain period of time in various newspapers and so forth. And that way people that may have creditor claims against you can hopefully see that and file a claim. So it's a longer process, and obviously it takes a lot of those assets potentially away from the family and to pay those debts that normally wouldn't be paid if an estate wasn't opened.
Got it. So for people that have credit card debt when they pass away, how does that typically work? Who's responsible for that debt?
The estate, if it's opened.
Okay. Gotcha.
And obviously if the credit card's in other people's names too, they could be held responsible for it. But if it's a solo owned credit card and an estate's never opened, I don't believe anybody ever has to pay for that.
In terms of your house and your car, those are things that would be in your will, correct?
Yes, you can. I mean, they can, depending on your circumstances. First of all, with your car, you can leave whoever you want to have it, and all they have to do is take your death certificate down to the DMV and they'll transfer the title on the vehicle. Same thing with your home. If it's homesteaded property and you want to leave it to your kids or whomever, again, they go down to the clerk's office at the courthouse and they take the death certificate and they will file a petition for homestead, and then it'll transfer the house to them. So it's real easy. And that's why I kind of go back to, depending on the assets that you have, kind of determines whether you need just a will or if you also need a trust.
But for anyone watching right now, so much of what I'm passionate about with what I do and what you do is that you can fill out one piece of paper. You can go, if you have a 401k, usually there's a tab you can open to add a beneficiary. You can spend 2 minutes adding a beneficiary to your account, and it can save your heirs time. It can save them a lot of money. You want your money going to who you want it to go to.
Absolutely.
So for anybody watching right now, I want you to pause and take that 5 minutes, list all of your accounts, and see if you have beneficiaries on them. And if you don't, take another 5 minutes and add them, because it's so, so important and people don't do it.
Or they don't change them. So I know a lot of what you do involves helping women that are getting divorced, and they forget to change those beneficiaries, and suddenly the ex is getting money that you would have never wanted them to have.
Took the words right out of my mouth. That was my next question for you. Okay, so let me ask you this. When you are talking to women going through divorce, people going through divorce, when do you tell them to change their beneficiaries?
Generally after the marital settlement agreement has been entered into, because you don't want a situation where, if as part of the negotiation, and again, now you're talking into family law, which is also not my area, but just kind of on the periphery and seeing what happens, in the context of if it turns out that at the end of the day, during the mediated settlement agreement, we decided we're going to share our retirement account and therefore you can't take me off of it. Well, then you got to go back and put me back on. So I always, I would always err on the side of caution. And if you're in the middle of the process, wait till it's completed and we know what the final agreement is, then make those changes to the beneficiary.
So when you are making your post-divorce checklist, and if you're working with a financial advisor like me, it will be on your divorce checklist post-divorce. Update your beneficiaries, because if you are divorced and you forget and you still have your ex's name listed as beneficiary, your ex is going to get that money, correct?
Well, yeah, if they're still listed as a beneficiary, absolutely. Yeah, whoever the beneficiary is, that's what's going to be deferred to by the life insurance company, the bank, whomever. And you'd have a hard time fighting that. I mean, well, you won't be here to do it, but your heirs would have a hard time fighting
your ghost is going to be really mad. So make sure that you update your beneficiaries to who you want them to be.
Absolutely.
And another phase of that, happier phase, when you have, well, two things. Let's start with step one. When you enter into a marriage, is there anything estate-wise? You probably, like you said, they might want to be your POA clone. Are there any other things that you kind of walk through?
At that point, if it's just getting started, it's just your basic estate plan. Having your wills, having your powers of attorney, healthcare surrogate, living will. There's another document called a pre-need guardian. So there's just sort of these what we call ancillary documents, and making sure those are in place. And then depending on what the status is of that particular couple, whether a trust is a good vehicle for them at that point in time. And if they're planning on having kids, sometimes it's good to go ahead and do that now. And then we just make amendments to it once the kids are in place. Or sometimes we just wait until they have the kids and then put a trust together at that point.
So can you walk through when people have kids, what kind of trust? I hear the word guardian sometimes.
Well, you definitely want to set aside whomever it is that you want to be the guardian of your children in the event both of you pass away. There's two ways to do that. You can do it inside the trust itself. There's also a document called a pre-need guardian, and you do a declaration of a pre-need guardian. I've done it for my daughter, and it gets filed in the court file. No one gets to see it, but if for some reason both myself and my husband pass away, the court would look to that document to see who we have addressed, who's the person that we've designated to take care of our daughter until she becomes 18 years old. And so you file it in the county where you're living in. If you move to a different county, you do have to move, refile it in that county. But because the court, they will only look within their own county. And so they're not going to do a statewide search. But you look and basically the court will defer to that person who's listed in that pre-need guardian document. So that's one way to do it, kind of, I don't want to say on the cheap, but if you don't really need a trust, that's certainly something I recommend regardless when you have minor children, so that somewhere it's listed who you want to take care of them. But within the trust document itself, absolutely, you can include who you want the children's guardians to be. In fact, you should, because the point is that they're going to, if they're minors, they can't just be given a bunch of money. Somebody's got to take care of it for them. I have a client where we're working on amending it now that they've had their child. And we've got people that are designated as the guardians should something happen to them. And then we have fiduciaries that are taking care of the finances, setting aside different things for the people that are going to care for the kids, not only for their care, but also to supplement them. So there's different ways that you can put it together in a trust to benefit and help not only your children, but the people that are going to be taking care of them for you as well.
I love that. And so let me ask you this, because I was talking with a friend about the podcast and she was like, I really want you to touch on the women who are single, and not just single and looking to date, but women who are single, they're past the point of having kids. They might not have nieces and nephews. They might want to give money to charity. What advice do you have for the single women who are looking to do estate plan, looking to make their estate plan?
That's a really good question. I think that, with every client, regardless of their status and what their situation is, you want to find out what their interests are, what matters to them, what's important to them. And so, there are clients who, regardless of what their interests are, all their money's going to their family, and that's fine. But you have plenty of clients that want to diversify, and they do want to leave money, whether it's to charities, whether it's to causes that they believe in. They have pets, they could set up a pet trust to take care of their animals for them. There are different options, and you definitely want to find a lawyer who's willing to be creative with you and help you explore other ways to leave your wealth to other people or other organizations. There are some that you can put it into just a charitable remainder trust, and you designated the types of areas that you're interested in, and the fiduciary will make sure that the funds are used to those types of situations. Had a client that had left a certain sum of money to a particular religious organization. Well, that religious organization changed sort of their focus away from what this person had really wanted. And so the fiduciaries then took that money and diverted it to an organization that was more in line with what that person wanted. So there's ways that they can kind of their wealth sort of lives on beyond them and takes care of other people and helps other organizations.
So in terms of a pet trust, that was one of my questions for you, because I'm not a human mom, but I am a dog mom. And I know people worry about what's going to happen to their pets when they pass away, because a pet is a member of your family. On another note, my mom wants to get a bird. Apparently birds live like 100 years sometimes.
A very long time.
Yes. And I have had clients that have like passed down a bird for like a generation. It's crazy. Can you go into more detail on what a pet trust is?
Well, yes and no. Okay. So because every case is unique and different. So I'm not going to say there's square peg, square hole, round peg, round hole when it comes to a pet trust, because it depends on the type of pet you're talking about, the longevity of the animal, what care they're actually used to having, who's going to be taking care of that person, or that pet, excuse me. So you have to have all of that information together. So you want to really be thinking about, okay, I'm going to leave my dog to my sister, and my sister and my dog goes to this particular vet, and my dog eats this particular kind of food, and and I want to make sure that my dog gets walked 3 times a day, whatever it is. You can be as detailed as you want within that trust. And the person that's taking over is supposed to do that, and hopefully does, because they care about you and they care about your animals. So there are definitely ways to do that. It's a little more complicated than a standard trust, because we are talking about, animals that aren't able to come up and go, hey, wait a second, you're not doing what you're supposed to.
I'm only getting walked 2 times a day.
So there's more that goes into it, but definitely it's an option. And we're seeing it more and more, because to your point, a lot of people that don't have children or don't have the nieces and nephews, but they do have the animals that have been a very important part of their life, and they want to make sure that they're taken care of in the event that they're no longer here.
And just to be clear, you can fund a pet trust with money. You
Absolutely.
Can say to somebody they're getting X amount per month, or you have money earmarked for their vet bills and their dog food. Am I getting that right?
Absolutely. No, you're absolutely right. And you can do it different ways. You can do them as a beneficiary of your life insurance policy if you want, if it goes into your pet trust. But yes, you can absolutely, and I recommend putting money into the trust for the animals.
So to clarify, mostly to myself, you cannot list your dog or cat or horse on your life insurance policy.
No.
However, you can list the pet trust and the name. Can you put the animal's name on the pet trust?
Yeah. I don't see any reason why not.
So you can do that. And then peace of mind that your animal is taken care of. Yeah, that's great. Okay, cool. It sounds silly, but it's not.
I know.
I worry about that.
Yeah, it's very important. I agree.
Yeah, 100%. And also, a lot of our animals, specifically mine at this time, are used to a very nice standard of living. So who are they?
I can only imagine.
Oh yeah, who are they to have to downgrade just because I'm not here anymore? That doesn't seem right or fair.
I can assure you my dog would not appreciate downgrading.
No, certainly not. Oh my goodness. So in terms of second marriages, third marriages, anything but your first marriage, or you have a first marriage where you don't have kids and then you have kids your second marriage, or vice versa. A lot of times I'll have clients that'll have kids from their first marriage, not their second, or from both marriages. How does all of that work?
It's more and more complicated every day. I would say, first of all, I would say for anyone that's going into a second marriage or third, to look into a prenup. And again, that's not something I handle. You'd want to call a family lawyer for that, but I would definitely recommend that. We have an episode
on that.
There you go. So I definitely recommend that, because obviously, especially if you have, amassed a certain amount of assets, if you have developed your own business. I was talking to a potential client the other day. As a matter of fact, she's a business owner and she's on her second marriage. And she said, I need to get my paperwork in line. I said, sure, give me a call. We'll talk about it. She said, because I'm not letting him have it like my first husband got everything, which was ridiculous. And so I said, I understand. And I mean, nobody likes to think about it. She's very happy with her second husband, but let's face it, 50% of marriages end in divorce. So usually if it happens, it's the woman that ends up on the short end of the stick. So if you're not planning ahead and preparing for it,
Preach.
It's, you're just setting yourself up. So absolutely, that would be my first recommendation, is a prenup. You can do postnups. They are far more difficult. If somebody wants to challenge them, it's a little bit easier to challenge a postnup, but if done right, it can still be enforceable. But then indefinitely, especially if you have kids from that first marriage or that you want to leave things to, then I think a trust is a really good option for you. And certainly, having a will that has specific designations and separate accounts that are designated for those kids. So as long as it's in your name only and you want to leave it to your kid, that's absolutely your right.
I advise clients when they're going into second marriages specifically, if they say, well, I don't want to spend the money on an estate planning attorney, can you talk a little, they're like, well, sure, my spouse will do the right thing. Can you talk a little bit about if you don't have the right documents in place and you are married, how do things default?
Well, I think that it gets harder. I mean, if something were to happen, we do tend to default to our spouse. And to some extent, the doctors will still do that. The courts will still do that. But it's not a guarantee, first of all. But secondly, it may not be what you want either. And so, an estate planning attorney is not going to bankrupt you. All right. Like I said, it's a flat fee, and that fee depends on, what exactly we need to do for you. We're not the cheapest, but we're also not the most expensive. And we do offer a free consultation. So you get the benefit of at least finding out if we're the right fit for you, and also kind of go over what it is that you need to make sure that what we can provide is what absolutely is the right thing for you. And if it's outside what we are comfortable doing, we will tell you, you need to go see a tax attorney. You need to go see a business lawyer because you own your own business. Get that set up first before you come back and do the estate planning. It's sort of like buying insurance, Taylor. All right. I don't buy life insurance in hopes that I die, right? I buy life insurance, and if I do die, things will be taken care of for my family. I pay a premium for that every month to have that benefit, to know that it's done. Life and estate planning is the same way, except it's a lot less expensive, and it's usually a one-time fee, and then you're done. And that is, it's funny. You clients come in, and that's exactly what they're worried about. Like, I don't like to think about this. I don't want to talk about this. And yet, once we have that signing appointment, and you can just see the relief on their face when everything's done, it's like, that wasn't so bad, wasn't that expensive. And now it's done. Now I don't have to worry if something were to happen.
Exhale.
Yeah.
Yeah.
Exactly.
Nice. Okay. And I tell clients too, I say, listen, you get what you pay for. So it's not something you want to cheap out on. Make sure that your wishes and all the money you're working so hard for, make sure it goes where you want it to go. Mm-hmm. Do you have a ballpark, a range, if you will, just so people aren't going to go somewhere and get ripped off?
If it's a single person and we're just doing one set of documents, depending on how detailed they are, if there's no trust, then it's around $1,500. If you're going to need a trust, it's probably going to be between $2,000 and $2,500 for that. If there's two people, then it's $3,000. And then if it's two people with trusts, then it's probably closer to $5,000. But again, it's a one-time fee. You get all of your documents. We maintain whatever you want us to maintain. Of course, we maintain copies of everything regardless. But if you want us to maintain the originals, we do that. We give them to you on a flash drive. We give them to you in a hard copy. We've got a nice little binder with everything together. So it's one and done once it's done. And then if you have any changes, you call us. And like I said, if it's a minor change, then we just do that at no cost to you. If it's, hey, I just got divorced, I got to redo my whole documents, well, then we're going to have to pay for that. So.
Yeah. And just for anyone who hasn't used attorneys before for anything, $5,000, even on the more expensive end, is a fraction of what you're going to end up spending. If there's anything where there's any discrepancies and there's any kind of probate that gets opened up, am I on track with that?
You're absolutely on track. When people start fighting over money, the only people that make the money is the lawyers.
Right.
Sort of like divorce lawyers too. But no, definitely in the probate world, yeah, you're going to spend far more trying to collect what should have been yours in the first place than if you had just done everything and your family had done it right, so that you're taken care of as well. And you don't want, you're not going to be here to know about it, but you don't want your family fighting about it when you're gone.
And that's the other piece of it, I think, that's huge, is that the more you can plan out, especially when you have multiple children. I had a client one time that had 9 kids. They didn't fight. And I said, the greatest legacy you have to your parents is the fact that 9 of you could get through this. There was a trust in place and all of that. But they didn't fight. And then I've had 2 siblings where it's just, it ruins the relationship. So the more you can kind of direct things while you're alive, to your point, there's so much less fighting on the back end of things. Do you see people disputing wills a lot?
I don't personally, because we don't handle probate, but that's when it comes up, is if somebody files a will and somebody says, oh no, that's the wrong will. There was another one that they did, or I didn't, and that's when you end up getting probate litigators involved and actually having to hire lawyers and pay them hourly to take care of that. So I don't know how often it happens. And most of the probate litigation that I'm familiar with through the lawyers that I know that do that work, They're pretty large estates. I mean, you're not talking about people fighting over small amounts of money. It's usually 7 figures, easy.
It happens way more on TV, I bet, than it probably happens in real life.
A lot of things happen way more on TV than they happen in real life.
That's very fair. I wanted to ask you too, because I know when I talk to clients a lot, they get very excited about having a safe deposit box to put all their documents in. It's a hot button topic at my office. Can you talk about that? When you said like storing your will and your power of attorney, do we need safe deposit boxes? Does everybody need to go on Amazon right now and buy one? Like what is that?
Okay, well, if you're talking about a safe deposit box in your house versus one of the banks, there's two different things. So yes, I do think everybody should have a place to keep important documents. What we tell our clients, however, is that when it comes to your original will, because that's the only original document that has to be filed, okay? Everything else can be copies. But when you go to file a will, it has to be the original. There are some ways of getting around that in emergency situations, but generally just assume that the rule is you got to have the original. If your original will is in your safe deposit box at Bank of America or wherever you're at, and you die, and you don't have a TOD on that, can't get into that safe deposit box. And so now we're having to open up a probate without the will to open up the safe deposit box to find out what the will said, and the will may not have said. And I mean, like, it creates a big mess. So we always say, please don't put the will in the safe deposit box unless you know that it's properly designated and that someone can get into it when you die.
You've designated the safe deposit box.
You've got to do that. It's crazy. But yes, to have some place in your house that's fireproof, waterproof, to keep all your important documents, I absolutely think that's critical. I mean, we do live in a technological age, so everybody should have stuff scanned somewhere. And like I said, we always give you a flash drive with everything in addition to on the paper. But that original will, it does matter.
Wow. So you have to open up probate to get a key to a safe deposit box?
That's happened.
Mm-hmm. It's funny that you say that, because as you were talking about funding the trust, I feel like so much of estate planning can be like, you create like this gilded like gold box and you have to put things in it. Yeah. Otherwise it's just a really pretty, it's not, in my opinion, it's very affordable for the amount of work you're doing to hire someone like you, unless you're really not going to fund it with anything. And then in that case, you're just spending money.
Yeah, so spending money to spend money.
Right. Like getting the safe deposit box and paying for it's great. But if you don't put the beneficiary on it, it's another gold box with nothing in it.
Yep. I had a client and we had to do that because we represented her for a nursing home case, and she had passed away in the interim, and her son came down and he became the personal representative of the estate. But until the estate was opened, he couldn't access the safe deposit box. It was crazy. He came down to Florida, and he was in the bank, and they're like, we can't let you in. He's like, what?
Oh, I have a question, especially for my snowbirds or my people that move a lot. Mm-hmm. When you move states, what do you have to do with all these documents?
It depends on how well they were drafted in the first place. Okay. So what I always recommend is if you had your documents done in another state, bring them in for us to take a quick review and see if anything needs to be changed. If it comports with Florida law, we're going to tell you everything looks good, you're fine, go about your merry way. There may be things that are a little bit different. Sometimes the powers of attorney that are drafted in other states aren't as comprehensive as ours and doesn't allow you to do as many things as you think you are allowed to do. So we would want to let you know that. But under the full faith and credit clause of the U.S. Constitution, which says basically every state's supposed to recognize and respect another state's laws, it really normally would not be a problem. The difference would be there may be some changes in like our HIPAA laws and from terms of privacy, in terms of what we can access with our certain documents. So we would definitely want to take a quick gander at them to make sure. But for the most part, you're probably okay as long as they were done properly the first time around.
What about for the snowbirds or the seasonal people? If you're half the year in Michigan and half the year here, do you need two separate things?
No. But like I said, I would make sure that you travel with your documents, and that it's probably worth it to at least check in with a lawyer in the other state to make wherever they weren't, the state that they were not drafted in, just to make sure that there's nothing that's unusual. There's different states have different laws. And so some of them are very, very different than what we have here in Florida. And that may make a difference if you were in that other state.
This is super important. I want to touch on this as well. Even if you make your will, you put it in your house, you put it in its special little spot, you have to tell somebody where the spot is.
Agreed.
So a lot of times, to your point, especially wills, I have to have the original document to give somebody a copy. So like we always offer that at our financial advising office. If you want us to have a copy, let us know. If you want us, some people, I think it can be to the benefit to go over with your kids what the documents say. Some people don't want to do that. But if you can, at least let them know or let somebody know who to contact. Because again, you can have all these documents, but I've had clients' kids, especially if they're from another state and then they come down to Florida, they're like, I don't know who they used for their estate planning attorney.
Exactly. And I think that's really the key. I think it's less about telling your kids what the documents say, because that can create all kinds of problems and you may not want to do that. But definitely letting them know, here's who you need to call in the event something happens, they know what to do. And whether it's the power of attorney, whether it's the will, or the trust document, whatever, we offer our clients different options depending on what they're comfortable with. And if they want us to hold the originals, we will hold the originals. We'll give them copies so they know what they've done. And then I tell them, tell your kids or niece or nephew, whoever it is that's your personal representative or your power of attorney, that in the event something happens, they should call us. And my clients, now obviously if they've passed away, then all I need is the death certificate. But if it's an incapacity situation and the niece wants to get the power of attorney so she can help uncle in the hospital, well, uncle's already left me instructions on she needs to bring you documentation from my doctors verifying that I am in fact incapacitated, and then you may give her the document. Just an example. But that's the best way. Tell your kids or whomever you want to know who they should call, and then make sure that attorney also knows under what circumstances I am permitted to release your documents to somebody else.
And super important, I think, to mention is when it comes to your documents versus your direct assigned to, for example, if your will says all your money goes to Susan, but the beneficiary attached to your investment account says that it goes to Jennifer, who is the money going to?
On that account, it's going to Jennifer.
Yes. So good news
Thank you.
is,
Appreciate that.
Yeah, no problem. I don't know who Susan is, but doesn't really matter because she didn't get any money.
I got the money, so it's good.
It's all good. Sorry, Susan. So something very important that I always tell clients is that peace of mind that I mentioned before. Not only can you add the beneficiary, but it supersedes whatever your other documents say. It's good to make sure that they match. Mm-hmm. But again, for anybody watching, after you finish watching this, if you didn't pause before, go add beneficiaries to all of your accounts. And the other thing I was going to ask you is, I think everybody should hire you, Jennifer. But if they can't because they're in another state or they don't live anywhere near here, what should people be asking estate planning attorneys that they are looking to hire?
Well,
how do you know if you have a good one?
Yeah, I would say, first of all, you want to check prices around. And again, I think it's like anything else. You do get what you pay for, but that doesn't mean you should go with the most expensive, nor should you go with the cheapest. Mm-hmm. People can go on LegalZoom and download documents and say, okay, I got it executed. And I look at it, I'm like, yep, you executed it. Doesn't really say much.
It does have a signature on it.
Doesn't do much, doesn't do anything that you want. So, certainly look for other recommendations, friends and family who they might have used over time. Most every state bar association has referral networks, and so they can give you the names of attorneys that handle that work. There's the probate and trust section within each state bar that will have members as well. That's a good place to look for recommendations. But obviously, first and foremost, friends, family who if they've done their own estate planning work for sure, then who they liked, or maybe they didn't like them and don't call them. So whatever they're comfortable with.
Okay, what if you have somebody living in your house, like a partner, but it's not their house? Mm-hmm. How does that work when you pass away?
So that is a really loaded question, Taylor.
That's why I asked you.
I know you did. So, but it involves several things. So if someone has been living in your home for an extended period of time, now we're getting into landlord-tenant law.
Oh no.
It's amazing how many things are tangentially related, right?
Yeah.
So you would have to see, depending on what you want done with your house, what their situation is. Do you have to formally, so you're leaving your house to your daughter, for example, but yet the guy that you've been living with is still there. Daughter wants to get him out of there. She may not be able to right away. She may have to go through a formal eviction process. He may have rights if he's lived there long enough. If he's done capital improvements to the home, he may be entitled to certain things that way. So there's a lot that goes into that, which again is outside my purview. But you definitely, in that context, I would send you to a landlord-tenant lawyer to find out what can be done. What rights does this person have, depending on how long they've lived there, if they've contributed financially, if they've made capital improvements. A lot of different things would go into that. So at the end of the day, can you get them out? Yes. A simple answer, but the more complicated answer is how that's going to happen and how long it will take.
So to kind of nip it in the bud from the jump, I have clients, typically it's going to be older people that don't want to get remarried and they have a partner that lives with them. If they're making that decision and they haven't made it yet, what documents pertaining to estate planning do they need to put in place? Is it like a life estate? I'm just throwing out legal words.
You're right. You're not incorrect. You're not wrong. So yes, you can leave that person a life estate if that's something that you want to do. If you want them to be able to continue to reside in the home until they pass away, and yet the home itself goes to whomever you want to leave it to. But in that circumstance, that person is permitted to stay there until they pass away. So that would keep daughter from kicking him out. But if that matters to you and that's important, certainly that's one way to take care of it. I would avoid titling anything in that person's name otherwise, because then they are definitely going to be able to keep the house and do what they want with it, depending on how the title is done of the deed. But certainly you can leave a life estate. That's one vehicle for sure, and allows somebody to stay there until they pass away.
So to be clear, it's the life of the partner. It's not your life.
Correct.
So it's the life of the partner.
The idea being that I'm passing away, I'm leaving my house in a life estate to John, and John is able to reside in there because his interest in the home is a life estate. And so he can't pass it on to anybody else, but he can stay there until he passes away.
So in that example, you can still bequeath the house to your kids once that person passes away.
It is bequeathed to them initially with him having a life estate interest in it.
What else do you want people to know about estate planning?
I think, you've covered a lot of it. It's never too young to start. Those documents that are necessary when you're still alive are so incredibly important, and that kind of gets glossed over in this idea of, I need a will or I need a trust. Yeah, that's for when you're dead. So the other documents from our perspective are so much more important in the immediate time frame, because you want to know that if something unexpected does happen to you, that your wishes will be followed, that the people that are going to be designated to make decisions for you are people that you want making decisions for you and making the decisions that you want them to make. So it's sort of a whole package. And I think people don't always think about it in that term. And maybe that helps them feel more comfortable contacting an estate attorney, because we're not just talking about death. We're not talking about leaving things after we're gone. We're also talking about keeping our things together while we're alive and making sure that everything is tied up in a little package with a nice pretty bow on it.
Make it as easy as you can for your beneficiaries.
Absolutely.
And I actually am going to touch on this from the financial planning piece of it, is when you're talking with your financial advisor, some buzzwords that you're going to want to talk about are step up in cost basis. It depends on the person, much like everything else that we all do. It depends on what your assets are, but sometimes you can have what's called a step up in cost basis when you inherit property, whether that's securities or so like stocks, bonds, or if it's real estate. So just having that conversation with whoever you have as your financial advisor. And same thing in terms of looking at the tax impact of gifting while you're alive, looking at gifting once you've passed away, finding an advisor that can have those conversations with you, really just trying to help you with guiding questions of what to ask, because the answers are different depending on the person. But you really want to take a look at, are there step up in cost basis? Taking a look at if you need to make a beneficiary IRA, what does that look like? Mm-hmm. Just kind of taking a look at your financial advisor and your estate planning attorney should work together when you're trying to figure out these documents, because to your point earlier, how things are always interrelated when you were talking about how landlord law all of a sudden affects your estate planning. It's the same with financial advising, intersects a lot with estate planning, and just making sure that you know which questions to ask, and making sure that your estate planner has an advisor they work with, the financial advisor, and vice versa, that your financial advisor should definitely have estate planning attorneys that they're in touch with, because you want to make sure when you have that comprehensive wealth planning that you've got all the people on your team that you need. So I'm so happy that you're part of my team,
No, absolutely.
Jennifer Beltz.
Very happy to be here as well. And you're absolutely right. And I think one thing I would say too is, while we work together and are complementary each other, it doesn't mean that as a client, you have to tell each of us every single thing. So when I talk about my clients and I ask them about their assets, I don't need to know the dollar value of each of those accounts. I just need to know generally, what do you have, so we can make sure that we protect that asset. And for you, I'm sure, obviously, you do need to know the specific dollar amounts on what's going on. And your financial advisor doesn't always have to have all of your estate documents either. They just want to know that you've taken care of it, so that they know that in the event something happens, they'll know what to do.
And then the other piece of it too is if you are leaving assets to charity, there are ways where you can mitigate taxes while you're alive. It gets a little more complicated, but it's something to where if
Tax
that's
attorney.
something, yeah, and then you have a tax attorney. I call it sometimes LOL, lots of lawyers. People are like,
You're not wrong.
I'm like, there's a lawyer for that.
There is.
If the question's hard to answer, you probably need a lawyer.
Right. And it's funny when you say it that way, lots of lawyers, but I would say that a competent lawyer probably focuses on one area. Estate planning is a complement to the practice we already had going. We don't take every single type of case that comes in our office. We don't take landlord-tenant. We don't do tax law. We don't do real estate law. So there are reasons why you need all those different lawyers, potentially, depending on the size of your estate, because each of them has specialized training. And that's what you want. You want somebody that knows what they're doing in their particular field.
And the other thing that people ask me a lot is, especially when it's clients' kids that come down, they're like, what do we have to do? Because mom or dad is going into assisted living. How do we hide all their assets?
Well, I'm not going to tell you how to hide assets. That would be very unethical of me.
Yeah.
What I would tell you is if there's a situation like that, first of all, if they still have money, they're going to have to use it. Okay.
Mm-hmm.
The government does require you to spend down before you qualify for certain benefits. And again, there are attorneys that specifically handle Medicaid planning issues. And that's a separate set from estate planning because what they're trying to do is make sure that you qualify for your benefits appropriately, maintain whatever assets you are permitted by law to keep, and then transfer to the extent that you're permitted to do that. But that gets tricky because there is a look back period of time where the government will say, oh, were you just spending down your assets to try to qualify for services? So again, that's a specialized area of the law. You want to contact an attorney that does Medicaid planning. There are plenty of elder law attorneys and estate planning attorneys that do that as well, but it is a very special area.
And I love that advice because that really is true. It's just making sure that you find somebody. You don't want a jack of all trades attorney. You do not want one. You want somebody that specializes in whatever you're trying to do. And they do overlap a lot. So LOL, lots of lawyers. I'm glad.
I'm going to steal that. I like that.
I'm glad that you're on my LOL team.
Me too.
So Jennifer, thank you so much for coming on the show.
Thank you. It's a pleasure.
Where can everybody? It's been a pleasure for me too. Where can everybody find you so they can see more of you?
Oh gosh, probably the website's going to be the easiest, which is beltsandbelts.com. We have a whole section under estate planning that you can look at, read some blogs, read some articles. We're on the various social media sites. I'm ancient, so I'm just learning how to do all of that. But you can follow us on Facebook, on Instagram, Twitter, I guess is X now, LinkedIn, various iterations of Belts and Belts. You should be able to find us. If you go to our website, you can sign up for our newsletter, which goes out once a month over email to kind of on a variety of topics, but just kind of keep you updated on how things are going in the law in the areas that we focus on. And we also do mailers usually quarterly, so to remind people like estate planning and things like that. So happy to get you on the list and keep you updated on what's going on.
Thanks so much, Jennifer. Thanks for being here. Update your beneficiaries, everybody.
Please update your beneficiaries.
Thanks so much for coming on.
Thank you.
Thank you all for listening. And remember, until next time, your wealth suits you better when it's tailored. Good job.
I love that.
That was great.